Audio check.
Thank you, Pura team, for getting us going this morning. Good morning, everyone. Welcome back to docket number 241004, the application of the United Illuminating Company to amend its rate schedule. Oh. Graham. All right, we'll continue. It kind of figures my first time up, right? All right, we're here for a scheduling conference in this matter. As the parties and interveners are likely aware, the appointed and qualifying commissioners granted the United Illuminating Company's petition for reconsideration with respect to several determinations made in the authority's October 28, 2025 final decision. The authority also issued a procedural order inviting all parties and interveners to file correspondence by 4 o'clock yesterday, December 9th, outlining the timeline of any requested procedural steps leading up to the authority's final decision on or before March 5th, 2026. So we're here today to discuss the December 9 filings and any other procedural or scheduling matters. Before we begin, I will take appearances from any attorneys representing a party or intervener this morning. Please take a turn at your respective microphones to state your name and affiliation for the record. How about we go clockwise, starting with Consumer Counsel, Claire Coleman.
Sure. Good morning, Commissioners. Claire Coleman, Consumer Counsel. I'm here with Kim White, Staff Attorney for the Office of Consumer Counsel.
Thank you.
Morning, Commissioners. John Ryder.
Morning. I'm Susanna Nigro from the Department of Energy and Environmental Protection, and I'm joined today by Attorney Sarah Solars.
Good morning, Commissioners. Brendan Vaughn from Keegan Werlen LLP on behalf of the United Illuminating Company.
Morning, Commissioners. Thomas Lopez on behalf of the Office of Education Outreach and Enforcement, and I'm joined by my colleagues, Attorneys Brittany Wyman and Attorney Jamie Spanik. Thank you.
All right, thanks very much. So let's turn to our discussion of this, December 9 filings by parties and interveners in response to the authority's procedural order. We'll begin by inviting UI to briefly walk through their proposed procedural steps and timeline, after which any party or intervener will be able to comment on the UI proposal. After that, we will hear from proposals from other parties, also followed by comments.
Thank you.
Attorney Vaughn.
Good morning, Commissioners. UI appreciates the Commission giving us the opportunity for the prompt ruling on our petition for reconsideration. The issues we selected were types of issues that would normally be raised on appeal. Issues of law and rate-making standards. We're seeking to avoid that through the reconsideration process. And we're looking for a reconsideration decision that addresses those errors of fact and law and develops, predictable and consistent rate-making standards for this case and for the future that are legally sound. We think that the best way to do that is in the process that we outlined yesterday, that particularly includes a statement and framing of the issues and having technical sessions with open dialogue between the Commission and the company's subject matter experts. So as outlined, the dates are pretty self-evident, but we would propose that by January 7th, 2026, the parties file a statement of the case on each of the three issues raised on reconsideration: the English Station ROE penalty, the compliance ROE penalty, and the O&M items contained in the petition for reconsideration, that we hold one or more technical meetings on the statement of the case to allow for dialogue and questioning between the Commissioners, other parties, and the company's SMEs on those issues, And then provide a process for, briefing, the standard steps, briefing, draft decision, written exceptions, culminating in a final decision on March 6th. We're flexible in how it gets done, but we do think that that approach with the framing of the issues and open dialogue through the technical meeting process is the best approach to reach a decision by March 5th on the reconsideration issues.
Thank you, Attorney Vaughn. Let's go around, we'll stay in the same order and invite the parties and interveners to provide any feedback, comments on that presentation.
Sure, thank you. Claire Coleman, Consumer Counsel. I think at this point, and as reflected in our submission yesterday, we have more questions than positions. And we just want to ensure that the process that's set forward is fair to all parties and that procedural due process is complied with in order to avoid future litigation. The questions we have are, one, to confirm that this would in fact resolve any issues that UI had with respect to its notice of supplemental filing of the CNG-SCG decision. Certainly, if there's going to be other appeals or requests for remands related to that, we don't want to create two processes where there's a reconsideration other. I believe, but we don't want to put words in UI's mouth, that this motion for reconsideration is what they are seeking with respect to the entire UI rate case process. And we just think it's important to clarify that at the outset so that PURA and the parties aren't sort of forced to defend iterative or redo iterative pieces of this case piecemeal. And then assuming this is the narrow set of issues that UI is seeking to address as I think Attorney Vaughn just said, to avoid an appeal. We want to make sure we're setting up a process that enables all parties to develop any record that's needed. And specifically with respect to the statement of the case, our question really is, what does that entail other than what's already in the motion for reconsideration from UI's perspective? And then finally, our concern with setting up technical meetings instead of hearings is that this is a contested case proceeding. If UI is putting on new evidence, all parties would have the right to cross-examine on that new evidence. So we believe we'd need to retain that procedural format of a contested case, of course, welcoming any additional dialogue that would be helpful to the authority on top of that.
Thank you. Mr. Vaughn, would you like to respond? Thank you.
Yeah, I was going to ask if I'd be entitled to respond. So if I heard Consumer Counsel Coleman correctly, and please correct me if I didn't. I mean, my understanding of is that, we consistent with the statute are entitled to seek reconsideration to address errors of fact or law. We did that with the 3 discrete issues before that we filed for in our petition for reconsideration before the CNG-SCG appeal came out. So this process is to address those issues. Now we are entitled to appeal, a final decision that comes out of reconsideration, or that if the decision on reconsideration isn't issued or is denied, we are entitled, we have appellate rights under there that we are reserving. And if we did appeal, it would be an appeal on all issues of the case. But for this reconsideration motion that we filed, we are dealing with the 3 discrete issues that we talked about. With respect to the statement of the case, I think what we were envisioning is that the evidence that exists in the record, stands and we think is sound. And we were envisioning not a brief, because there's legal briefing to take place, but trying to frame with the evidence in the case up for the commissioners and other parties. This is the issues that we raised on reconsideration. This is what we want to talk about. almost like a white paper, I think there's what we were kind of considering, this is what we think the rate making standards should be. This is where the errors of factor law are, and this is what, a building out of our petition. And that's what we envisioned for as a statement of the case. And technical meetings versus hearings, I think we're open to, if it needs to be called a hearing, we want to have a dialogue between our SMEs and others who would be participating, and, the commissioners and staff to help get to the right result.
Council Coleman, does that satisfy your question?
I think on the statement of the case, that's helpful clarification. I do have concerns about what we're hearing. It sounds like, and we're certainly not saying that UI wouldn't retain the right to appeal this motion for reconsideration, but given that UI has submitted the CNG SEG remand decision as a basis for reconsideration here and is only seeking to appeal 3 issues, it would be important to clarify that those are the 3 issues that UI is retaining the right to appeal based on the ruling on the motion for reconsideration that the authority is construing, not that it gets to come back and, appeal the whole thing after we've focused on these 3 issues.
No, we're absolutely reserving our right to appeal the entire case. I mean, that's how this works, is that we filed for reconsideration on the 3 issues, and that tolls the appeal period while the reconsideration process plays out. But then we do have the right to appeal the underlying, the final decision that is issued, whatever that final decision may be. So we're trying to avoid that, and I think that we can avoid that if we can reach a result here that's workable and that, with the issues that we raised on reconsideration. But we're not in any way waiving any of our rights ultimately when the final decision on reconsideration is issued.
Essentially, I interpret that as a sort of threat to Pura that if they don't grant this motion for reconsideration, there's a appeal looming on everything else. It feels like an inefficient process, but to your point, it's possible that it's all resolved adequately and avoids that.
Not a threat. And just to be clear, it's not a threat. But we are reserving our rights, and we're not going to be, gagged on what we can talk about or anything like that, or limited, or saying that, by filing this, we've waived our right to, appeal the final decision on the merits. No. The supplemental authority, that appeal petition was filed in this case because we think, through the draft decision, that the same issues were present in this case, and we do think it's germane legal precedent that can be discussed, on brief and matters for this case. But we're not threatening to appeal. We're trying to reach a result that avoids future litigation, and we identified these key issues for the company as ones that have been brought up on appeal in the past and would be brought up, I can see in the future. But we're hoping to address that through the current statutory process on reconsideration. We're not waiving any of our rights by doing that. And I think that we can proceed with the granted petition for reconsideration as we try to reach a final decision that, gives fresh eyes to the issues that were presented in the underlying case. And we think we can do that with a March 5th final decision date, and then, proceed from there. But we're not going to agree to waive or limit our rights based on this filing.
Vice Chairman Arconti.
Okay, thanks. All right, I'm gonna try to structure everything I'm hearing into my own words. First, I forget the date, but at oral arguments in the underlying docket, Commissioner Karen and I, we took a pause, asked if the company wanted more process. At the time, Attorney Vaughn, I don't want to put words in the company's mouth. So my understanding was the answer was no on more process, but the company and the parties did enter into settlement discussions, which ended, that resulted in a final decision. So I'm just gonna kind of ask again, are you asking, is there any ask for more process? All things considering, with the, right, because we had some rulings from Superior Court in the meantime, so I just want to throw that back out there as a question as well.
So I think what you're referring to is before we actually started the official oral argument, you asked if there was a break for discuss process. We met, we discussed, and then ultimately we did continue with oral argument because my colleague, Attorney Kimball, was prepared to go, and we weren't going to resolve the case, in that. So I do think we are here to talk about the process that
Yep.
that for the reconsideration. I don't know if we need additional, I don't know if you're asking if we need additional time or process other than what you've set out in the notice with the March 5th decision on reconsideration. We've provided the steps that we think provide sufficient process for us to present our statement of the case on the reconsideration issues and to brief them fully for you, meet with you through hearings or technical meetings and reach a result by that March 5th date. But I think that the process that we would be looking for now would be what is laid out in our December 9th filing.
So I'm going to ask some questions. I don't know if you can answer, but I'm going to ask them anyway. Let's just play this out. I'm talking purely hypotheticals. We get through March 5th. The company still wants to pursue its appellate rights. Again, that's your right. No one's arguing that. But would the appeal, right? Now I'm going to say this out loud. You're probably not going to be able to answer it, but would the appeal be focused on the merits or the process on how we got to the final decision? Because will it be, I'm envisioning is there a request for a do-over? Because I would rather do that now. The request is going to come, you know what I mean? If that is coming for a do-over, that'd be nice for the panel to kind of deliberate, kind of discuss now, if that's sort of the road we're going to have to go down for administrative efficiency. Does that make sense at all?
It does.
Okay.
I hate to say I can't answer it, but
I
I
figured
think
as I was
that what we're
talking-
trying to do, I think an appeal we would have to be able to reserve our rights to appeal the full case process and substance. We're trying not to, we don't want to do that. We identified these three issues for reconsideration before the Superior Court case order came out from CNG and SCG. We filed our petition for reconsideration on November 12th. That Superior Court came out, that the memorandum of decision on the CNG SCG appeal came out a week later. So these are the issues that we've identified as discrete areas that we would like to discuss with you and try to reach. We identified those as in our view, having errors of fact and law and meriting reconsideration. And we're hoping to avoid that through this discrete process that just addresses these three issues. If we had wanted to appeal it at the outset, we could have done that and we'd be within our window to have done that, but we chose to take the more targeted path, I would say, to try to reach an outcome that avoids an appeal.
Yeah, no, we appreciate that. I think that's why, we're all here. Always want to create opportunities for more process. Again, just on the process part, again, as I say it out loud, again, maybe one of the things can or can't answer. But if, right, on a potential appeal, this is why I kind of bring up the question of a do-over, right? If the process was not up to standards for the parts of an ultimate FD that you didn't like, does that also mean the process was also not up to standards for the parts of the FD that the company was not objectionable to?
I think what I would say about that is that the process, we know that it's our position that the process in this case was flawed through, at the very least, the draft decision. And we appreciate greatly the steps that yourself and Commissioner Karen took and Pura staff to amend the draft decision and reach a better outcome. there remained areas of concern that we're trying to address through this targeted outcome. But yes, I think that we would have to be, it's hard to speak in hypotheticals like that about what we would say at the end of at the end of March 5th. But what we're trying to do is avoid that through this targeted approach that we've come up with only on reconsideration discussing the 2 ROE penalties that we've identified and the O&M items that we've identified.
Okay. I think I'm good for now. I've fleshed out some of my internal thoughts. Thanks.
Thank you. So we're going to go around and hopefully before we conclude the discussion, we're going to try to have real clarity about process here. Attorney Wright for Office of AG.
I understand the
Thank you, Robin. So I'm just not sure this is the best use of the authority's time to go through a pathway to reconsider certain individual issues that ultimately are not going to make a difference on whether this is appealed or not anyway. Nonetheless, we're agnostic as to a schedule. We'll accommodate ourselves to anything that the Bureau finds reasonable or necessary. And would hope that this is that the end result of today would be the most productive use of the next few months before this goes to appeal anyway.
Feel free to comment.
Sure. I don't believe that it's appropriate to characterize this as like an appeal as some sort of foregone conclusion. We are, again, here to try to, on a limited number of issues, reach an outcome that we've identified that would help avoid future litigation. I disagree with the characterization that this will be some sort of exercise in, getting more so that we can then appeal, because litigation is time consuming and costly and takes resources. And I think that ultimately what we're trying to do is, if we had just wanted to appeal the entire case at the outset, we could have done that. It would have been within our rights. We identified these targeted issues and that's what we're trying to address. I don't think that it's some sort of, foregone conclusion, and we think that the process that we've laid out is fair and consistent with the notice and the granting of the petition.
All right, let's
I'd
hear.
only like to respond that this was not intended as a criticism of the company. These are unusual circumstances, to be clear, and we all recognize that. So it was not intended to criticize UI for suggesting the current path forward, just concerns over whether that's the best path available.
All right, that's what we're here to figure out. So, Attorney Nigro for D. Or Attorney Solars.
Good morning. Good morning, Commissioners. I think, again, the Department of Energy and Environmental Protection would echo what's been stated by the Office of Consumer Counsel and the Attorney General's office. In our filing, we did provide a suggested timeframe, and I think what you'll notice is we did specify that an evidentiary hearing is warranted in this matter. So we did lay out a timeline that considers that as the process. We think that would be a better mechanism than a technical meeting because, as was previously stated, this is a contested case and there should be evidence in the record that supports the ultimate final decision rendered by PURA. In addition, I think that on the topic of evidence, also UI provided as attachments to its motion for or petition for reconsideration specific documents. And that is what we see as the very limited scope of the evidence open for reconsideration. We don't think that the process should involve bringing in additional evidence. We think that would be fair to the parties to understand at the outset that these are the specific documents or pieces of evidence that UI is wishing to introduce, that they have the opportunity to introduce that evidence and that we as the parties have the opportunity to cross-examine on that evidence. And I did want to just seek some clarification because two of the items, attachment 1 and attachment 2, are one a memorandum of decision from a superior court and then the other the motion ruling. And I just wanted to clarify whether or not the commission or the commissioners are taking judicial notice of those pieces of evidence and therefore, will those already be in the record, or is there additional process around introducing those pieces of evidence that was very specific to kind of what the next steps look like for those two attachments. But I believe that pretty much sums up again what our position is at DEEP. We did lay out a timeline that we think would be feasible. I will also note it did deviate from UIs in that we didn't account for a draft decision in this matter. And for that, again, we, open to discussion what the best process looks like. But we do think it'd be appropriate for legal briefs and an opportunity for arguments before the final decision is issued.
Vice Chairman Arconti.
Yeah, just a question on that, because I did notice the difference in the two schedule proposals. And so a lot of great lawyers around the table, so I know I'll get an answer. Can anyone point me or cite a statute that requires a PFD? Who wants to go? Attorney Vaughn, you look ready.
Well, I'm getting ahead of myself a little bit. I know there is a statute that says that when all the commissioners have not, heard the matter or read the evidence that a draft decision will be issued.
Okay.
I don't have the citation because I'm not a robot, but I can find it pretty quickly. I know that there's a new compilation of commissioners and only yourself and Commissioner Karen voted on the ultimate, the final decision. So obviously there'd be time there. It's a typical step. I know it's probably more work and compresses things on different ends, but it does help. I think I tend to like the draft decision process as a way to narrow issues and understand where thinking is at so that we can, either identify errors or things of that nature. But I do think that it is a good appropriate step to take and continue with. And I can find that citation while I go on mute.
Thank you.
Like, have it,
Yep,
is that ready?
Attorney White.
It's general statutes, I'm sorry, Kim White, OCC. General statutes for section 4-179 is the section regarding proposed final decision. And it says that you issue a proposed final decision if all of the members of the agency have not heard the matter or read the record.
Thank you.
In response to the question raised about items in the evidentiary record, we're probably going to loop back to that. But we would take it under advisement. We'd give notice in the record as to if anything is noticed. So, all right, let's see. I guess, did you have any other further thoughts?
I would just note that I believe some of those attachments were already included, like had been filed in the case. The memorandum of decision and the motion ruling related to English Station had been filed, I think, on September 9th in the docket. So they are already in there. The the letter from the mayor of New Haven, obviously that was new, that came out after or right around the final decision deadline and could not have been issued, but we did file it here, so we can deal with that as a.
That was,
Excuse me. Yes, I recall that those were filed. That was after the close of the evidentiary record. So again, clarification from Pura would be warranted here to determine if those are already in the record. Thank you.
all right, so we'll just note this time that the attachments to motion rulings are not evidence, so we will, deal with this as we proceed. So now let's hear from Pura's EOE and Attorney Lopez, Director Lopez.
Thank you, Commissioner. EOE would essentially echo what the OCC, the Attorney General's Office, and DEEP have said so far. Ultimately, this may be an inefficient process, and I'm just not sure, without a waiver of appellate rights in certain matters, right? I'm not sure what we're doing here, right? So I don't know how we would proceed here without a waiver of certain appellate rights. So ultimately, right, what is there, as Attorney Vaughn has said, they will present a statement. And so, I mean, my question is without receiving exactly what they want, and is this really to enter into settlement discussions? I mean, I'm not sure where we're going with here, and what really the process they're requesting here. And so it appears to me to be an inefficient process if this is going to be appealed anyway. And again, right, as recognized, we understand their appellate rights. I think we all recognize that and understand that, but this just seems potentially to be an inefficient process to get to that place. Thank you.
Attorney Vaughn.
Thank you. Thanks, Director Lopez. I guess my response to that would be that we have a statutory right to seek reconsideration, and we've exercised that right. And to, the petition's been granted, and to, deny us that process because we also have a right to appeal can be said of any petition for reconsideration, and almost entirely moots the statute, right? Because you could say that about anything. Anyone that has the right to ask for reconsideration also has the right to appeal. And if you don't take up any reconsideration petitions because an appeal may be forthcoming, then what's the purpose of the statute? So I think that, when a final decision comes out, there are several paths forward, right? The final decision can be accepted if it's, depending on its content, it could be appealed under 4183, or you can ask for reconsideration. And we felt that the reconsideration path would narrow the issues and hopefully get us to a result that would be almost like step one, where we can live with the final decision without further litigation. So I understand that over the past years, appeals have been taken to protect the utilities' legal rights. I understand that this new decision has come down, but I don't think that it's a foregone conclusion that an appeal is coming. And I don't think that the existence of the company's appellate rights is sufficient reason to deny us a process or to ignore the petition for reconsideration. So I do think that our proposed schedule, which is pretty consistent with what Dee put forward, with maybe one or two tweaks on the margins, and including, we included that statement of the case, but I do think that represents an appropriate path forward, consistent with the statute.
Okay, so we have a few questions, and then we will return, just so everybody knows, we will have a chance to hear from parties about their filings specifically. But so just to clarify, is the company proposing to admit any other evidence into the record besides the letter from the mayor of New Haven filed as attachment 3 to the motion 122, and information on the company's compliance efforts to wind down the water heater program filed as attachment 5 to the motion? No,
I don't believe that we are. I mean, barring something coming up,
that we're not aware of, you know, another letter or some other evidence. No, as of right now, this is the evidence that, the additional evidence that we would propose to be admitted. This is what we're aware of, and this is what we put in the case. So I think that's what we would be leaning on.
Okay, and how do you envision entering those into the record?
Well, we did file them as motion attachments. We can include them with our statement of the case. We can have witnesses adopt them at technical meeting or evidentiary hearing, depending on how you'd like to, you know, adopt them as additional late file exhibits or something of that nature. You know, the record was reopened, so I think we have some latitude as to how we move those into the record.
Okay, do you have a proposal or position on allowing other parties to have an opportunity to introduce evidence into the record or conduct further discovery on any of the evidence introduced into the record?
I don't have a proposal on that. I mean, if we're limiting the new evidence that's issued to the two documents, you know, I suppose other parties can, you know, cross-examine on that, could put on you know, if they sponsored a witness, they could put a witness on to talk about those documents, but this is what we had envisioned were these things. I don't know what contradicting evidence there would be from that, but I'm happy to discuss how that looks procedurally.
Okay, just a couple more. The company's filed proposal includes statements of case filed by January 6th. Can the company explain what these documents would contain? Are they essentially pre-technical meeting or pre-hearing briefs? And that might give us some clarity on process.
I think that's a good analogy. So we proposed a January 7th submission date, and almost like, I don't think we were envisioning like a full legal brief, but setting out a document akin to like a white paper or something like that, setting out, you know, what occurred, what we think was wrong, and yeah, akin to a pre-hearing brief, but hopefully less dry and legal.
And how would you envision parties and interveners participating in a proposed technical hearing or technical meetings?
I would envision that the company would likely provide certain SMEs to discuss some of the issues involved, make them available for cross-examination. We have Mr. Hurwitz in the room, who the new commissioners, I'm sure, will get to know quite nicely as one of the company's senior director of revenue requirements. But I can see Mr. Hurwitz and his colleagues being present in the room and subject to cross-examination on the contents of the statement of the case and of the underlying discovery that went into the case on these issues. If other parties put in a statement of the, you know, what they feel to be framing up the issues, then I would imagine that they would have a witness that would be subject to cross-examination as well as to far as those parties' positions.
Thank you. Commissioners, any questions, comments on what we've heard so far? All right, we'll hold that for the next round. So let's now invite Consumer Counsel Coleman to provide an overview of OCC's filing and express any other ideas or concerns at this time. Thank you.
Sure, just to try to streamline the process as much as possible. We do note we have no objection to the authority taking administrative notice of the two attachments. We believe they're public records. So if that facilitates the incorporation of those, we have no objection to that. Given this is a contested case, we reiterate our position that it's more appropriate to hold a hearing where the appropriate witnesses are subject to cross-examination as opposed to a technical session. And Other than that, I welcome other parties' input.
And that covers your proposed, your proposal for the,
So I guess the only other thought I have, we did not specifically address the statement of the case in our written response because I think we had questions about what that is. It sounds like the company has no new evidence other than those 2 documents. So there's really not a need to explain anything further than what's already in their motion for reconsideration. It feels like we could skip that step, get to the evidentiary part, and then all parties could have the opportunity to brief their positions, be more efficient.
thank you. Do any parties have a response to the OCC filing or correspondence?
I think I offered my response to the bulk of it on the first pass as far as the, you know, the CNG SCG document. Appreciating your willingness to acknowledge that those public documents as far as the new evidence. You know, we're flexible is how we get there as far as I've said, but with the technical meetings versus evidentiary hearings. But we do think that the statement of the case would be value, you know, add value to help frame up and focus the evidentiary hearings a little bit. But again, you know, in the rest of it, we're flexible on dates and process. But that's what we're going for, and I appreciate that. I don't think it's an easy skip. So I would, you know, I know it sounds a little it's new. It's not something that has been done, but I do think it could add value here where we're focusing on a limited number of issues and rate making matters.
Thank you. Attorney Wright, would you like to discuss your filing? Oh, I'm sorry.
Again,
Thank you.
I'm not used to that. We're comfortable, we'd again, echo the comments of the Consumer Council for, both the admissibility of the exhibits and, proposed scheduling framework.
Thank you very much. How about from Deep?
I do believe that we primarily addressed what we provided in our filing, but I will also echo what OCC stated. We didn't put anything in our filing about the statement of the case. And from what we've heard from Attorney Vaughn, it does sound like a reiteration of their initial petition for reconsideration. And since this is already a very limited matter in scope, as we've discussed, I don't know how beneficial it would be to add that additional process to this and agree that it might be more beneficial to just jump right into the hearing.
Thank you for that. And how about Director Lopez?
Thank you. Sometimes it's easy to go last because I don't have really anything additional to say. That's all. Thank you.
All right. Do the commissioners have any additional comments, questions? Yes. Commissioner Cheeseman.
Thank you, Commissioner Beecher, and I've heard everyone's comments on all sides, and I think we're all in agreement. No one wants this to be a duplicative or inefficient process. On the other hand, the parties are right. They cannot waive their right to an appeal. I think the more quickly we can resolve the scheduling issues and get this underway and allow this to be reassessed and looked at with new eyes, given everything that's gone before us. And we do have new eyes looking at this. And I think the goal, and I don't want to speak for all the commissioners, is to have an open, transparent process to reach the best decision in keeping with our statutory requirement. And I want to thank everyone for their willingness to participate in this and look forward to going down this path. Thank you.
Thank you, Commissioner. Any last comments or thoughts at this point? All right. So in closing, the authority anticipates that the policies and procedures set forth in the October 22/2024 notice of proceeding will govern, including the 7-day response deadline for motion responses, guidelines for settlement proposals, and process for requesting docket schedule changes. We reiterate the authority plans to issue a final decision on or before March 5th, 2026. As we close out this scheduling conference, it sounds like everybody's fairly well satisfied with where we are at this point. And that sounds like the commissioners are good to go. So on behalf of Pura, we want to thank everyone for their participation this morning. The commissioners will take the written proposals and today's discussion under consideration, and will publish a revised docket schedule for this proceeding shortly. We are adjourned. Thank you so much. Have a good day.